interrogatory applications which have been filed. The nature of the application is that you can consolidate them, so we will put you to your election to pick the one you want to argue first.
My Lord, respectfully, we have a request to admit facts. That is not at this stage an application before you. It's a request that we have filed to the first respondent to admit certain facts. So that is, strictly speaking,
not a motion.
That is correct.
But you could see application for interrogatories.
Yes, the application for interrogatories is actually the only application that is before your Lordship.
Thank you. So.
Move in terms of the motion paper and the supporting affidavit. We're seeking your leave to serve interrogatories as exhibited, Exhibit A, on the first respondent.
Yeah, Mr. Chikata, under which rules of the Supreme Court's jurisdiction in election petition are you invoking our jurisdiction?
It is the combined effect of CI 1605 and CI 47 CI 47 order 22 rule 11. My Lord, evidently CI 47 is the High Court rule. I'm well aware of that. But your Lordships have ruled in the election petition of 2012 and 2013, which is reported in the special edition of the Supreme Court of Ghana Reports 2013. Your Lordships have made it quite clear that your Lordships apply CI 47 where there is no express rule that is in the Supreme Court rules themselves. And I don't know whether your Lordships want me to go through that authority. It is fairly well known. So Your Lordship's ruling in respect of the matter of interrogatories is to be found from page 50 of that special edition, and it was a ruling delivered on behalf of the court by Justice Badegbe. And the part where he refers to CI 47 is at page 54. Where he says, it does appear to us that the framers of the rules of this court envisage a gap in the rules regulating the practice and procedure in the Supreme Court by making a provision to that effect in Rule 5 of the Supreme Court Rules 1996, CI 16. In this regard, we think that the current High Court Civil Procedure Rules 2004, CI 47, particularly Rule 12.6 of Order 11 on application for further and better particulars and Order 22 on interrogatories are beneficial to us by way of guidance as to the appropriate practices to prescribe in the course of the exercise of the original jurisdiction of the Supreme Court. It is Rule Order 22, Rule 1, that is expressly referred to in that decision. It is to that order. It is to that order that we make reference when I stated that we are coming under Order 22 of CI 47. And my Lord, that statement of His Lordship Justice Badegbe is further reinforced by the provision in Article 1284 of the Constitution of the Republic of Ghana. Article 1284 provides that for the purposes of hearing and determining a matter within its jurisdiction and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So the Constitution makes it explicit that your lordships have the power that is vested in every other court. I'm sorry, 1294. 1294. 1294. I read it right, but I didn't. 1294, yes. My lords, the clear purpose of discovery under CI 47, the clear purpose discovery, interrogatories are part of it.
Okay, in that sense, okay.
And I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court. And my Lord, all the proposed interrogatories, and there are 12 of them, in our respectful submission, are designed precisely to narrow down the issues for trial. Your Lordships will, if I may respectfully refer to Order 22:1, from where your Lordships will see, which is headed Discovery by Interrogatories. And 1.1, a party may apply for an order giving the party leave to serve on another party interrogatories relating to any matter in question between the applicant and that other party in the cause or matter, and B, requesting that other party to answer the interrogatories on affidavit within such period as may be specified in the order. We want to then, from 11 is the answer that will be provided. We have complied with the Form 10 in the schedule in indicating what we are asking for leave to serve by way of interrogatories. And your Lordships will observe that starting from number 1 in the interrogatories, where